Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Code Interpreter, already sworn.
All right, good morning. Okay, this is Ada Reguera, and let's verify that she understands how this works. All right, and go ahead and speak to her.
Ada Regueira.
The defendant can hear me, Your Honor.
Let's say again.
The defendant can hear me, Your Honor.
The defendant cannot hear you.
She can,
Oh,
yes.
she can hear you, okay. All right, and this, tell her that she's been arrested for battery, domestic violence battery, and that it is a misdemeanor. And is there anyone in the audience? So when we call a name of a defendant, then I need for you to come into, if you're here about that name, come into the box over there, and then I'll give you instructions. So, and I think there's one of the court, the confinement representatives out there who will help you. Okay. Now, ma'am, so we don't have anybody on the other side here. Let me. What is, ma'am, what is the relationship between you and the alleged victim?
Ella es mi hija.
She's my daughter.
Okay, that's what all right, I remember reading this. So she lives with you?
No.
No.
Okay, she was just simply visiting when the incident occurred?
No, ella fue a la casa a recoger sus pertenencias para entonces irse a vivir a otro lugar.
She was coming to the house to pick up her belongings and go live somewhere else.
Okay, all right.
Your Honor, respectfully, within the affidavit, the victim's testimony is that she does co-inhabit the apartment with her mother and father located at that residence. So in the conditions, state would just ask for a separate residence just to make sure that that is clear.
Right. The defendant has no prior history. It was a mother-daughter argument, and so we'll go ahead and do a $250 bond. And so I put it as a low bond so you can bond out easily. And then she is, your daughter, this premises is yours, and so you're to have no contact with your daughter at this point until this case is over with. Just no contact with your daughter. And no alcohol or drugs. And state, is there any other conditions?
Your Honor, state was requesting a separate residences and a one-time return
Right.
just in case, as well as no weapons.
Well, no, she lives in the premises is in your name, correct, ma'am?
Mi residencia sí.
All right.
Yes, it is.
Your Honor, this court does not have jurisdiction over the victim. The victim does live there. That's why the state's asking for a separate residence at this time, just in case to avoid any future conflict.
Well,
Mi hija no vive conmigo. Mi hija
have
My
you
daughter
and
doesn't
your
live with me.
daughter had problems in the past
nunca.
of this kind, physical
Never.
problems? Are you afraid of your daughter?
No.
Do you
Nope.
fear that if I allowed you to live with your daughter in a no hostile, nobody mad relationship, that you can do that? That will be successful?
Sí.
Okay.
Yes.
Your Honor, state would object to no hostile. The victim is not here to testify, and it's alleged that the defendant grabbed her by her wrist and hit her with an open hand on the left side of her face, and then punched her approximately 10 times. Due to the victim not being here to testify today, under Florida statutes, state would be asking for a no contact and a no hostile. Again, we don't know the victim's wishes.
Well, is the apartment is this a rental or do you own the premises?
En el apartamento donde vivo es rentado hace 8 años.
The apartment that I live in, we've been renting it for many years.
Okay, and is both you and your daughter on the lease?
No, está mi esposo, mi hija y yo.
It's my husband, my daughter, and myself.
Okay, so there's a husband in the household still?
Sí, eso es correcto.
Yes, that's correct.
Okay. All right. I think, given the totality of this situation, I'm going to allow you to return to the house, no hostile contact, and do talk to her about her moving. Now, I don't have jurisdiction over her, but it seems like, and the state is not unreasonable in their request, but it just seems like this is at an end, this relationship. So whatever you want to do there, so no hostile contact, but I would recommend that you and your husband tell her she needs to leave, but that's up to whatever arrangements you make. But I don't want to see you back here with another incident, do you understand? Okay, all right, thank you very much.
Your Honor,
Que ya la nena se mudó.
Your Honor, the defendant testified that the victim is on the lease.
Que no,
For the
para
skirt.
hacerles saber a ellos que ya ella se mudó de la residencia. Ya ella se mudó.
I just want to let you know, she already moved out of that residence. She moved out.
Okay, good, good. And let's not have her come back in under these situations, okay? Okay. All right, next we have,
Your Honor, if the interpreter may get the case number from Ms. Reguera.
It's 21 MM 9261.
Thank you.
okay, and Guillermo Ortiz Vaughn, I'm probably messing it up, but, so are you Guillermo?
Correct.
Okay. And so this is a violation of probation. The VOP court will be in a few days. What's the time frame now? 3 days? 4? It's about 3 days. So the bond is 0, and you will address bond and anything else in the VOP court. All right. What do we
The ASA says that he's on, if you don't mind going back to Cisco.
say? I say again.
May the interpreter get the case number from Mr. Guillermo Ortiz?
It's 21 CF 677.
Thank you.
And was that
And
it?
that's it for Spanish for right now.
Okay, that's it for now. And so thank you very much.
Not a problem, Your Honor.
Okay. And we do have at least one attorney. So what case are you? So we'll be glad to call your case now.
Your Honor, we tried to log on to Cisco earlier for the attorney that was appearing.
Oh, was
virtually.
that
It
case?
is on, so if you mind pressing the button to.
Okay,
bring
do
that up.
we want to try that again?
Sure.
Tell me the instructions. Okay, call. Video conferencing. Okay.
Welcome to an Econo meeting. You are entering the meeting now.
Okay, we do have a person. Oh, there it is up there also. Okay, sir, if you want to come over, are you on?
No, Your
Oh,
Honor.
he's not. Okay. All right, let me come back here. Okay, now I've got in front of me an order. Let me get a pen. It says last name is Rush and the last four numbers are 5191. And so this is a 33-day order, so granted or denied. So state if you would put who you are on the record and then tell me what we're going to do.
I'm sorry?
Okay, state who you are for the record and then tell me the state's position regarding this order.
Andrew Schrager for the state on the Rush matter. State would object. Tomorrow is the 33rd day. We have printed it information. I'll be in the office later today to formally file it.
Okay, this order says, granted, the defendant will be released on their own recognizance if an information or indictment is not filed by the end of the 33rd day. The defendant's 33rd day is December 30th. And
Correct.
So I would just, I'm going to go ahead and mark that as granted. And so, so tell me if that, so they would be released on own recognizance if an information or indictment is not filed. So you would file it and that would void the release.
In theory, Judge, my concern is that something will get lost in translation, and although we will file today, somebody who is processing it will see the granted order and then just release Mr. Rush. So I'd ask that you hold off on granting that order until the 33rd day itself, as is custom.
Okay. Well, I understand what you're saying, and I tell you, today's the 29th, and so I tell you what, we'll just bring it up tomorrow. So any reason I can't just bring it up tomorrow morning? Is it the
Not
same?
that I'm aware of, Judge.
Is there any problem with doing that? No, I don't want to cause a problem. And so, but be honest with you, the last few days that I've been doing this court, I've signed many of these orders. And so there I understand your apprehension, but I'm surprised. So I'm going to go ahead and grant it.
Your
And,
Honor.
and so just be aware that it's been granted and the person will be released at the end of, tomorrow. When do they release people? When it says here, the 33rd day is, so do they release them at midnight? Do we know?
Your Honor, that's currently the issue, is prior to, the PDs have started filing a new motion that is in compliance with the rule. The rule states that you can file it on the 30th for release on the 33rd. However, it's never recalled on the 33rd. And we don't know the procedures that the jail goes through, whether they look to see if information is filed on the 33rd, since it's never recalled in court. No one knows what's happening or if they're being released because the jail sees a release order prior to that date. That's the concern that our office is now trying to figure out, because the PD's office has changed their motion as of approximately about a month ago. They used to file them on the 32nd to be heard on the 33rd. They're now filing on the 30th, 31st for release on the 33rd, which isn't in compliance with the rule. However, I don't believe the jail procedures have also been fixed to comply with that rule as well.
Okay.
So that is what we're currently
All
trying
right.
to figure out.
Can defense be heard?
Yes, sir.
We are in compliance with the rule. It does allow us to file the motion on the 30th day, and we wrote the order in a way to allow the judge to sign a preliminary order for release on the 33rd day, which is why we spend a lot of time dating them specifically from the 33 days from arrest. What was happening was we were filing them on the 30th day, and then they were being denied because they were filed prematurely, and we would have to do it again on the 33rd day to have it reheard again because state hadn't filed charges. So that was the issue, why we started to have them heard perhaps on the 30th day, but have the preliminary order for release on the 33rd day. I think that was, we are, again, regardless of jail policy, I think our motion is still within the rule of criminal procedure. And we were trying to avoid that gap where we filed on the 30th day and the order was denied because it wasn't the 33rd day for release.
Well, you know, this court meets every day of the year, and so why wouldn't you just do it on the 33rd day and to go ahead and release them?
In Your Honor,
Wouldn't that
I'm
just be
sorry.
simpler?
In regards to the jail's policy, the issue is if you're granting that motion today, that's the only order we're going to have when we go back to process it on the 33rd day. If the state files, the order you're putting granted. So we will have to release that defendant unless another order comes through.
And so nobody really checks if an information or indictment is filed on the 33rd day?
I don't think they go back to check it, but if they do, the only order we have is you saying it's granted. If the state files it, who's going to give us another order stating that it's going to be denied to not release that defendant?
Because the case is never recalled for the judge.
Exactly. So that's why in the state's favor, it's best for you to go ahead and deny it.
Your Honor, may defense be heard again? I believe they do regular checks of inmates that are here that should be released, especially when it comes to the 33rd day motion. The rule allows us to file the motion on the 30th day, and we've taken the extra step to include in our order the date for release, the 33rd day, specifically for this issue, so that people can see the order and the date of release. So we're trying to help with efficiency. We're not trying to hinder it because we are dating them specifically. If we were just writing orders with a blank release on their own recognizance, then that would be an issue because we don't know for sure what day they are entitled to release. However, we've put the specific date on the order for the judge to consider, for Your Honor to consider, because we are within the rules of filing on the 30th day, but also we are including an order that details the date for release, the 33rd day.
Your Honor, just
So,
to alleviate the situation, can you grant the motion today and it be recalled tomorrow so you can deny the motion?
It's already been reset, Your Honor.
It was reset from yesterday due to the PDs having the wrong dates on the order.
And we don't know if they're going to file today. They say they're going to file today, but we don't know for sure. So they could come to us tomorrow and say, well, we were going to file yesterday, but something came up. We're going to definitely file today.
And then that's fine,
We'll
then
do it
it would
all
still
over
be
again.
granted. It'd be granted twice. So the PDs,
We've had an issue too where it was granted in the morning and then they filed it an hour later and then we had to try to deny the order.
Well, has this been printed to where we can redo this order? I just messed it too many times. I tell you, I'm going to go ahead and grant it, and I'm going to initial because I went back and forth, but I'll go ahead and grant it. One of the reasons is because I've done a bunch of them without this issue really coming up, and so I think the issue may be more theoretical than real, but from a jail standpoint, the order says if, and so if means the jail should check, and I'm also thinking that really people shouldn't be released until the 33rd day, and maybe at 6 o'clock at night or 7 o'clock at night or something, but not 12:01 or even 8 o'clock in the morning. So the 33rd day, it doesn't have an hour. So if I was running the jail, I'd keep them until the end of the business day and then check it. And so
Judge,
I'll go ahead and grant it anyway. Okay.
Judge, just that you write on the order, 12:30 at 6 p.m. if an information has not been filed.
Okay, the defendant's 33rd day is December 30th. After 6 p.m., parenthesis, 1800 hours. Okay, so the end of the day, you have that day of the 33rd, which is your point. You may be filing at the last minute. And so you've got until 6 o'clock on the 30th, and then just we'll see how it works. All right, thank you very much. Did you have anything else?
I do not, Judge.
Okay, and frankly, all right, well, thank you very much. Okay, all right, we have an attorney, if I can, I'm trying to help you.
Yeah, I understand. My name is Mr. Wassinger, Attorney Matt Wassinger. I'm here as a friend in support and help for Christopher Hughes. I'm the family attorney for both him and his wife. And so
What's the last name?
Christopher Hughes.
Christopher Hughes.
I'm not formally representing him in this. I'm here to help at the behest of his wife, if I can.
Okay. Jail corrections officers, is Christopher Hughes available or not? He may or may not be available.
It's a misdemeanor DV.
Here's a Christopher Hughes. I found it. It's a battery, domestic violence. Okay, yeah, let's see. As a,
I'm sorry. No, she's not here.
okay, you can come over to this podium over here where there's a microphone, and when we get them out here, and so for the record, we are calling Christopher David Hughes, and would you state on, now that we're on the official record, who you are, please?
I'm Attorney Matt Wassinger. I'm a personal family attorney for Mr. Hughes and his wife.
Okay,
To support
so-
help if I can.
So the attorney is not here to represent the defendant, but simply as a character witness, as any other person who would come in the morning.
Yes, Your Honor.
Okay. All right, are you Christopher Hughes?
Yes, sir.
Okay, Mr. Hughes, this is a domestic battery, and glancing at the cover sheet, you have no prior arrest, and let me go down and glance at this. And so this is a husband-wife situation. Some children were present. Oh, yeah, this is the buckling the seatbelt type argument that happened, correct?
Yes, sir.
Okay, that's what I remember reading this. All right. The state, is there any aggravating thing that I need to know about?
Your Honor, just the presence of the 3-year-old.
Okay. I'm going to give you a bond of $250, and see, one of the problems is without her here, I can't really let him go back. The law is and procedure is generally the wife would be here and say that she's not afraid of him, and you know the routine.
Yes.
And so I'm going to be here tomorrow. Tomorrow's my last day of serving this period. And so if she wanted to come tomorrow, I could change can't I? I don't see any reason why. $250 so you can get out. There's no reason to have you in jail. But procedurally, I'd have to say no. See, without her being here, that causes a problem. So let's have no contact, reside somewhere else for, a couple of days or whatever. And if you and so if she comes tomorrow, I guess we could keep this paperwork. If she comes tomorrow and says that she's not afraid of you, that this was an isolated incident, and that she's okay with you coming home, then I'll just change it tomorrow to where you could. State?
Your Honor, respectfully, state would object. The victim was notified to be here today for this hearing. It is within the 24 hours of his first appearance, which is dictated by rule. And she was notified, and she did not choose to be here or could not be here. And pursuant to the rule for resets for an additional day, you already found probable cause. Therefore, this court has no jurisdiction to reset it for an additional day just to see if the victim will appear.
Well,
It would still ask for no return or no contact, separate residences, a one-time return, no weapons, and that can be modified by Judge Shoemaker in Division 50 at a later time, who is the judge that will have jurisdiction over this matter.
so we can either do the normal release and exactly what the prosecutor said, or you could call her to come this morning or this afternoon and solve the problem. She may not want him to come home.
Well, Your Honor, I'm here at her behest. So if the no contact order, at the very least, she would be okay with no hostile, no unwanted contact instead of a strict no contact order. If that's something we can do without her needing to come down here, or would an affidavit be sufficient?
No, you're an attorney. You're ethically bound to always tell me the truth, and I'm sure you're not going to risk your license for stupid stuff like this. You know what I mean?
Again, Your Honor, state would object. The victim is not here to testify as to her wishes. I understand Mr. Wassinger is putting on record that she would like contact. However, under Florida statute, she is not here to testify that she wants contact. And without that, that court cannot set a no hostile. This case can be heard in Division 50, where the victim has a right to be present at, if they want to change that no contact at that time. However, state's objecting due to her not being here. And I understand counsel's here. However, he's not retained in this case, and I don't believe he's been retained as victim's counsel either. He's here, as he stated, as a family friend, and this court has to take both the defendant's interest into account as well as the victim's. And given that she is not here to say her wishes, state is vehemently objecting to a no hostile at this time.
All right, and so as far as I'm concerned, I'm interpreting what I've heard this morning as that he has come here at her request to advise that she's okay with him returning to the home and no hostile contact. Is that correct, sir?
Yes, Your Honor, no hostile contact or no unwanted contact at the very least, if is what she advised me.
Okay. All right. I'll go ahead and allow him to return to the home, no hostile contact, and no alcohol, no drugs. Do you have any weapons Any firearms?
Yes, sir, I have one at the house.
All right, you have to turn those over to the sheriff. While the case is pending, turn the firearm and any of the related ammunition over to the jurisdiction of whether you're the sheriff or the police department. So turn that in, and I do want pretrial release. I want you to turn it in, get your receipt, and then bring it to pretrial release. And pretrial release, you can let me know, and I want that done today. And
I believe
is
you
that
have to
okay?
be put on pretrial release for pretrial release to be,
To supervise that.
to supervise that, Your Honor.
No, I don't mean supervise. I mean to receive the,
They won't have record of him due to him
Oh,
not being
okay.
on pretrial. though.
okay, then to the clerk's office? Yeah, bring it to the clerk's office. So, since, while I was a judge, I had 2 women murdered in domestic relations. And so both of them were shot. And every day in Florida, there is a woman murdered by a domestic partner every single day. So right now, some woman's going to be murdered today by a domestic partner somewhere in Florida. And so would you, as an attorney, but also make sure that this happens? If you're going to have him get out of jail, then I want everything to go smoothly as everyone else in this room does. So I want either her or him or somehow I want the ammunition, weapon. What kind of weapon is it?
To be honest, I'm not even totally sure. My dad gave it to me, and I've just put it in the closet,
Yeah.
up and away from my son and my wife.
Well, turn it in.
Never
and-
even shot it.
Well, I have one of those weapons too, that I inherited from a grandfather, and I've never fired it. So I know exactly what you're talking about. So I'm going to hold this for tomorrow, or somehow to remind me tomorrow, and I'm going to check on the clerks. So I want today for you to, I've tried to show you respect and to show you confidence that this was an isolated situation. But if you have not turned in those weapons and brought the receipt to the clerk's office and told them what I've said, they'll put it in the system. Then I'm going to issue a capias for your arrest, and I'm not going to be a happy camper. So I'm trying to show you respect, but I expect you to show me respect.
Absolutely.
Okay. All right. I want it done by 8 o'clock tonight. Well, see, that's the problem. No, I want it done actually. I want you to turn in the receipt before 5 because the clerk's office closes at 5. So turn the receipt in by 5 so I can see it in the system.
Okay.
Okay.
Can the PD still be temporarily appointed until
Yes.
further notice? Thank you.
Yes. All right, so you don't need to be here if, when the clerk calls this up tomorrow, if she can tell me, yes, Judge, the receipt, law enforcement receipt is shown. So, okay, and thank you very much, folks, and can you help me
Thank you.
call that up tomorrow? Okay, let's, okay, Malcolm Cooper. Malcolm Cooper, please. Okay, Mr. Cooper, You have been arrested for 2 counts. One is attempted aggravated battery. Another one is throwing a deadly missile into a building. And so these are, let's see, these are, both of them are felonies.
Yes, Your Honor. The attempted ag bat is an F3. The throwing a deadly missile is an F2.
Okay. And so we'll go ahead and do
Your Honor,
$1,000
there is a
bond.
witness present.
Oh, I'm sorry. Thank you. Yes, sir, I need for you to come close to the microphone, speak up loud and clear, and tell me your name and spell your last name.
Clarence Cooper, Cooper.
All right, Mr. Cooper, I understand you were involved in this incident?
Yes,
Okay, and he's your son, right?
yes,
That's right, I thought. And so has this happened where he's lost his temper and done something either to you or to your property, like what alleged happened here? Has this happened in the past?
yes, sir. He has mental problems. He has ADHD and really high anxiety, and he's been trying to medicate himself with street drugs.
No, that doesn't work.
And that is the problem, sir. I've been dealing with it for a few years, and it's really, got out of hand, and he needs therapy.
Okay,
That's the problem, and
okay,
I just can't, he can't live with me no more. I don't want him to go to prison, but he just can't live with me.
okay, no, that's very good. I totally understand. So we'll go ahead and, first off, pretrial release. Can you drug test him once a week if I put as a provision of his release? Okay, so since addiction appears and some other issues appear, I don't want you self-medicating you. You can't use street drugs for ADHD or whatever the issues may be. It just doesn't work. And you're going to wind up in prison. And so, so at this point,
Your Honor, I have a question
yes.
for the witness.
Yes.
Good morning, Mr. Cooper.
Good morning.
Would you like to have contact with your son while this case is pending?
No, he need to be in therapy, ma'am.
Okay, thank you. That's all I have.
Okay. So we're going to have, we'll go ahead and put $1,000 bond on attempted aggravated battery, and then throwing the missile, we'll do it at $150. And then you are to live somewhere else. You do have the right to have law enforcement accompany you to get your stuff. That means your clothing, any work tools, and you are to have no contact. So you're not going to live with your dad anymore. I don't want you contacting him while the case is pending. When the case is over with, then we'll do something different maybe. And does your son have any firearms or ammunition?
No.
Okay. And so no drugs or alcohol. And if you test positive for illegal drugs or you're intoxicated, not intoxicated, but if you're drinking alcohol, that's a violation of your bond, your bail, I mean, and your bail will be revoked and you'll be right back where you are. So I'm giving you an opportunity to get out of jail. Now, does he have prescribed medicine?
They gave him at Inspire. He'd been to Inspire a few times, and they gave him medicine, but I don't know if he mixed it with the
Okay,
street drugs or
public
what.
defender, can you make a note that he really needs help getting probably the right diagnosis, the right medicine?
Yes.
Otherwise, we've just got a continual problem.
Yes, Your Honor.
All right, so the public defender, these are good lawyers. The public defender's office has a lot of good services to help you. So I want you to talk to your public defender attorney, whoever that might be, and explain to him that you've got some mental health issues and you may or may not have the ability to get prescription, diagnosis and prescription, whatever. But I don't want to see you back here just because you're addicted or mentally ill, and none of us want that. And so, okay, that's, have I forgotten anything, State?
Your Honor, State would still ask for the condition of no weapons, firearms, or ammunition.
No ammunition, firearms, anything else?
And I just wanted to make sure the defendant understands, I believe he signed a no contact order. That means it's also a no return to the scene. I believe it's no return within 500 feet is what's on that form. I just wanted to make sure he understood that, since there was also arguably a property crime that occurred.
Okay, no contact, don't be around your father at all. And one of the things the prosecutor just said, which I didn't say, basically it's stay 5 football fields. Couldn't you throw a football field? Can you throw? Neither can I. And so I want you to stay 5 football fields away from your dad, away from his house. And so let's work with your lawyer and let's get this thing done.
Yes,
All right, thank you. Okay, next we should have Jasmine Gowans. And okay, Mr. Gowans, you have a battery, domestic violence by strangulation, also battery, domestic violence. Do we have anybody? There's nobody in the audience. So we'll go ahead and, for the record, I'm looking at Florida arrest. He did have an aggravated assault with a firearm, domestic violence in the past. Correct?
Yes, Your Honor, he had an ag assault with a firearm, DV, an ag assault with a firearm, and a battery. But all of the victims were not the same victim as in this case, I believe.
I couldn't hear the last part.
One of the victim in this instant case was also a victim in that case.
Okay.
So it is one of these same victims as well as 2 additional victims.
Is this an F2, F1?
The arrest was June of 2021, so approximately 6 months ago. And the ag assault with a firearm are F3s, and then the battery was an M1.
Okay, and so the,
However, he's currently here for an F3 and an M1 as well.
okay, based on your histories, which is troubling, and then the situation, in this situation, your bond is for the battery by strangulation, your bond is $5,000. The domestic battery is $2,000. And you're to have no contact with the victim, no return, no weapon, no firearms or ammunition, and no illegal drugs. So let's go ahead and have pretrial release again to set him up to. So now, do you do that weekly? Okay, let's have a weekly drug testing. So no illegal drugs. And anything else, State?
No, Your Honor.
Okay, thank you. Next, we have Sarah Hamilton. Sarah Hamilton. Ms. Hamilton, you're charged with battery on a person 65 years or older. And is that your mother? Okay,
Your Honor,
and, yes.
may I be heard as the probable cause for the charge?
Yes, yes, go ahead.
As reading the affidavit, I didn't see an age for the alleged victim. It just says that the officer charged her battery of a person over 65, but I didn't see a birthday or an age for the alleged victim. So I would just have you find probable cause for a bad DV.
Okay, what the attorney is saying in essence is that the four corners of the paperwork need to be correct. And even though you told me, and by your age, I can tell that your mother is in the 50s or maybe 60s, I don't know. But I'm not allowed to, so really the paperwork has to support it. So,
Your Honor, it's on the witness form, which is a part of the affidavit that is also sworn to by the law enforcement officer.
can I do that?
It's sworn to by the law enforcement officer and created by the law enforcement officer with the victim's name, date of birth, and address.
Okay, let me find that. I tell you, the only thing about getting a little bit older is it's hard to read. This print is getting smaller and smaller.
It's alleged that the victim's
I
date of
see.
birth is 9/20/54.
So is that,
66.
so is that, this second page here, that is all together here, and so is it one document?
Yes, Your Honor, it's the affidavit that is sworn to under oath by this law enforcement officer, and he is the
Okay.
one that inputs that information.
Public defender, why wouldn't that be sufficient?
There's no argument at this time, at this point, Your Honor.
Okay, all right, and thank you for pointing that out. I never really looked at that other piece of paper. Okay, so we'll go ahead and have no contact with your mother. You do have the right, first of all, bond-wise, I see you have Florida or so fentanyl, and
Dropped.
and you have some other drug issues, paraphernalia, etc. All right, let's go ahead and we'll do $1,000 for your bond. And then I want you to have no drugs, no alcohol. Let's have drug testing once a week at pretrial release. And they'll give you paperwork as to how to do that. And then no return to the house except with law enforcement one time to get your clothing and any personal items of that nature. You're not to possess any firearms or ammunition, and the public defender has been appointed for this hearing, okay, State, have I forgotten anything?
No, Your Honor.
Okay, thank you. Next is Randall Jackson. Ma'am?
I can take that. This is where we can reach you? Is this the address we can reach you?
Yeah.
Zip.
Okay, Randall Jackson, please. Mr. Jackson, I have appointed, I think I said this in the beginning, but I do appoint the public defender to represent everyone at this hearing, subject to them qualifying for a permanent appointment. And so, Mr. Jackson, you're charged with lewd and lascivious conduct, also lewd and lascivious molestation. Are those F2s or F?
Yes, Your Honor, they're both second-degree felonies due to the age of the victim.
Okay, and so, you have no criminal background. There is an arrest on a marijuana issue, but some time passed. But so as far as these two charges go, the lewd and lascivious conduct by a person, that's $25,000. And then the lewd and lascivious molestation, and that is $10,000. And so you have, if you make bond, you're to have no contact with the victims or their family, no return to the scene of the incident, and no contact means to stay away from everybody directly or indirectly, no firearms or ammunition, and okay, anything else, State?
No, Your Honor.
Okay, all right, thank you. Next is Carlos Pantoja, I think it is, Mr. Pantoja. This is a battery committing domestic violence by strangulation, aggravated battery on a pregnant person. And then a third one, which is battery dating violence. And so, sir, we'll go ahead. I think we have, so State, the battery by strangulation, is that an F1 or F3, I mean?
Yes, Your Honor. The strangulation is an F3, the ag-bat pregnant is an F3, and then the bat DV is an M1.
Okay, so they're all F3s, did you say?
F3, F3, M1.
Internet.
Two F3s.
And, oh, M1.
Yes, the bat DV is an M1.
Right, okay.
The other two, since there's aggravating factors,
Right.
are F3s.
Okay, for the misdemeanor, we'll go ahead and do the $1,000, and then the battery domestic violence, we'll do that as $2,500. Sir, you're to have no contact.
Your Honor, there's 3 charges.
Oh, thank you. And then the last one, that dating violence battery, that's a misdemeanor?
Yes, Your Honor, you said 1,000 on the misdemeanor, which would be the battery DV.
Yes.
And then so that would be count 3. So you're doing 1,000 on count 3. You then said on the domestic battery, 2,500, which I assume you're meaning count 1, the battery by strangulation.
Yes.
So we only need a bond on count 2, the ag-bat pregnant.
Right, and we'll go ahead and make that $1,000. And sir, so you have no contact with the victim or the family, no return to the premises. If you live there, which I believe you may, then you can go there with a sheriff's deputy to get your stuff. One time, you just call the law enforcement and they know the routine. And then, so no firearms or ammunition, and no drugs or alcohol. And I don't see any of that in your background. So, okay, thank you very much. Next is Francisco Pina. Francisco Pina.
Mental health, Your Honor?
Mental health, okay. Madam Clerk, let's go ahead and call the case back once he's released from mental health, within 24 hours of being released from mental health.
Your Honor, usually they aren't released due to mental health within 24 hours. If we're appointed, may we just waive the appearance so we can have bond set today?
Right, so we'll go ahead and waive his appearance as requested by the public defender.
Your Honor.
And then possession of cocaine is $1,000. Possession of cannabis, $100. Battery on a person 65 or older, we'll do that $500. The second one, battery on a person 65 or older, $500. And looking, and then no contact, no residing, they have to live somewhere else, no contact. If need be, they can go with law enforcement to get their personal items from any residence that they share with any of the victims. And then no ammunition, no firearms. Since we'll go ahead and put no illegal drugs and to be drug tested through pretrial release. And I think that takes care of it, State.
And Your Honor, how often would you want him to be drug tested?
Do it weekly. Okay, and then Cameron Scott, Mr. Scott, this is battery, domestic violence by strangulation, and then battery, domestic violence. And these are felonies, both of them are felonies, I believe.
No,
And
Your Honor, battery by strangulation is an F3. Battery, domestic violence is an M1.
right, the battery, domestic violence is a miss M1.
Yes, count 2 is an M1, count 1 is an F3.
Oh, it's an F3, okay. All right, so we'll do the battery, domestic violence by strangulation would be $2,500 bond, and then the M1, we'll do that as $500. And then I do, okay, and then no contact with the victim, no return to the premises except with law enforcement to get personal items. And so no contact means no contact, no going over there, no phone calls, no nothing like that. And so stay away from the victim and find somewhere else to live. All right, thank you very much.
Your Honor, State would ask for also no contact with the witness, as there was an independent witness.
Yes,
as
all
well
right,
as-
we'll stay, no contact, in other words, don't have, now, the Public Defender's Office, they do a very good job of investigating their cases, and they can take depositions. So if you want anybody to be interviewed, you tell your lawyer, and they know how to do it without getting anybody in trouble. Because if you go do it, they're going to think you're tampering with a witness, which is a crime, and you're going to be right back in jail. So whatever you need done, please confer with your public defender attorney. All right, thank you. Did I cover everything?
So State was asking for no contact with the witness, comply
Right,
with
no,
DCF.
no contact with the victim or witnesses or their family. I think I read the other day that was always a good thing to say, and family.
Yes, Your Honor. State was also asking to comply with DCF as there was a child present, as well as no weapons, firearms, or ammunition.
Right. Okay, next, is it Michelle or Michael Williams, or Mr. Williams? This is a battery, domestic violence by strangulation. And I do note, first off, I do note that he is out on surety bond, $2,500. So we'll revoke the bond and we'll change and give him a new bond of that of $3,000. So he loses the $2,500 and it goes to $3,000. And then on this current charge, we'll go ahead and do the 2,000. Is this that's a felony? So we'll go ahead and do $2,000. And I do notice there is a drug issue in the past, so we'll go ahead and order that he be drug tested weekly, no illegal drugs or alcohol. Next, we have,
Your Honor, did you order a no contact or separate residences or?
yes, no contact, no return to the residence, has to live somewhere else.
Your Honor, is there a no weapons?
Right. No weapons, no ammunition. Okay, next we have Yeline Fabre, something close to that, I apologize. And so this is a battery, dating, violence, and is this an M3? I meant an M1.
Yes, Your Honor.
Okay. And, sir, if you would step close to the microphone, speak loud and clear, and tell me your name and spell your last name.
Yes, my name will be Willie Spatcher. Last name will be Spatcher.
All right. And, sir, are you the person involved in this incident?
Yes, Your Honor.
And what's your relationship to her?
Girlfriend.
And do you have any children together?
Soon to be.
I'm sorry?
Soon.
It's usually a yes or no answer.
No, no.
No, okay. All right, and do the two of you live together?
No, we don't.
No, okay. So there's no reason for her to come to your place, right?
No, Your Honor.
All right, and do you fear her?
No, Your Honor.
Do you fear that she'll cause you problems in the future as far as violence goes?
No, Your Honor.
And has she been violent with you in the past?
No, Your Honor.
Well,
Your Honor, one question.
yeah, please.
Sir, do you want to have contact with her while this case is pending?
Yes, ma'am.
All right, thank you.
Okay. All right. She has no real history, and so we can go ahead and have no hostile contact. Now, hostile contact means no arguing, no screaming, no getting mad at each other. If you feel that way, and speaking to you, the defendant, if you feel that way, then you just have to pick up your purse and leave. So don't stick around and get into a big argument, and the cops come and you're back here. And so no hostile contact means walk away if you feel angry. That doesn't solve anything. And so so you have no hostile contact. No illegal drugs, and you have to have no firearms or ammunition. Do you have any weapons, any pistols, rifles, anything?
No, Your Honor.
Okay. All right. At this point, I think we've done everything. Okay.
Your Honor, where's her bond amount?
The bond amount would be $500. No, let me change that. That's an M1, correct?
It is an M1, Your Honor.
Yeah. I tell you, in looking at your history, which usually I pay attention to, I really do.
Your Honor, the standard bond for an M1 is generally $500.
Mm-hmm. Yeah. We'll go ahead and do it $200. So he's willing to have you back so long as you're not arguing, fighting with each other, and you don't have any real history. So $200 is fine. And Okay, next for Jackson Georges. Jackson Georges. All right, Mr. Georges, you have a charge of battery, domestic violence. There is someone in the audience. So, ma'am, if you would get close to your microphone, speak loud and clear, tell me your name and spell your last name.
Tierra Bradshaw, Bradshaw.
All right, Ms. Bradshaw, are you the person that was involved in this incident?
Yes,
And has he been violent with you in the past?
yes,
And are you fearful of him?
yes,
And do you want to have contact with him or not?
no,
Okay. Do you have a child together?
no,
And do you live together?
yes,
Okay. And the lease is in your name or his name?
his name,
His name, okay. Are you going to be moving?
yes,
Okay. So have you, how long, have you already arranged to live somewhere else?
yes,
Okay. Have you gotten all your stuff?
almost,
Okay, all right. We'll go ahead and we'll do a bond of $500 and and you're to have no contact with her. No contact means no. No email, no telephone calls, no going to place of work or trying to follow her because you love her. None of that. None of that. Just going to get you right back where you are. No firearms or ammunition. And I do see drugs in your past, so we'll have no illegal drugs as a condition of your bond, and you're to report to pretrial release weekly to be drug tested. So I want you to stay clean, not contacting her at all, and move on with your life. Okay, thank you very much.
Your Honor, state would still ask for a separate residences to be ordered. It does not mean that Mr. Georges could not go back to the apartment. However, it would just ensure that if the victim was there picking up other belongings, he would have to leave until she left. So state would ask for a separate residences at this time, just to ensure that she's able to get the rest of her belongings before Mr. Georges
Yes,
retakes.
separate residences, in other words, don't live together anymore. It's your apartment, so you can stay there. But, and so, ma'am, now I think the victim could call law enforcement to go with them to get her stuff.
Arguably, Your Honor, however, this court doesn't have jurisdiction over her to make her do that.
No, I'm just saying, you do have the right to do that if you want to. Yeah, thank you. In other words, don't go there with him. Either send a relative, a friend, where there won't be any incidents to get your stuff, or you can call law enforcement and say that the court said that you could call them to accompany you to get your stuff. And a deputy will go with you or a policeman and getting your clothing, your personal items, so you have nothing in his place anymore. Okay?
okay.
All right, thank you very much. Thank you, sir. Next, James Lindig. James Lindig. All right, you're Mr. Lindig? Okay, if you can step a little closer to the microphone. You've been arrested for battery, domestic violence, and we do have someone in the witness booth. And so, sir, I need for you to speak up loud and clear and tell me your name and spell your last name.
David Lindig, Lindig.
And Mr. Lindig, are you related to the gentleman, to the defendant?
Yes, Your Honor.
I'm sorry?
Yes.
And how?
He's my brother.
Okay. So this was a fight between brothers?
Yes, Your Honor.
All right, and do you all live together?
Yes, but I moved out yesterday when it happened.
Okay, do you have all of your stuff?
Yes, Your Honor.
Okay, great. All right, and for the pendency of this case, which will take several months, do you wish to have no contact?
No, Your Honor.
Or do you wish to have contact?
Yes, Your Honor.
Okay, now, you've moved out, so we don't have a living relationship issue. Yeah, I remember he got mad about the dog, right?
Yes, Your Honor.
Yeah. And so, so let's have no hostile contact, which means that you can talk to each other so long as you're polite, civil, you know, no one's going crazy. And so you can have no hostile contact. Sir, do you have any firearms or ammunition? All right, so no firearms or ammunition. You have to live in separate residences. And so I think that's about it. State, is there anything I'm forgetting?
No, Your Honor, just the bond amount.
Okay. All right, remember this, put this behind you, and it'll work its way out.
Your Honor.
Bond amount?
Your Honor, can we have a bond amount, please?
Oh, I'm sorry.
That's okay.
We'll go ahead and do a $200 bond. Yeah, $200 bond. Next, we have Jessica Moore. And I think we have somebody standing up coming into the witness well. All right, sir, if you will speak loud and clear, tell me your name and then spell your last name.
Good morning, Your Honor. My name is Felix Perez, Perez.
Your Honor. Sorry to interrupt. I believe our client needs a Spanish interpreter.
Oh.
Okay, all right.
Oh, okay.
Thank you. Never mind.
All right. Okay, would you say your last name again?
Perez, Perez.
Barrett? Okay. So you were involved in this incident, right?
Yes, Your Honor.
And so, how are you related?
I'm her spouse.
Okay, so you're married.
Yes.
Children?
Yes, Your Honor.
All right, and I think you've been married about 10 years?
Over 10 years, Your Honor.
Over 10 years, yeah, I remember when I read that. And so, has she been violent towards you in the past?
No, Your Honor.
And do you fear her today?
No, Your Honor.
Okay, and if you were to get back to, if I allowed her to return to the home, well, first let me ask you, do you wish for her to return to the home?
Yes, Your Honor.
And if she returned to the home, is there going to be any chance of more violence or arguing or fighting or anything?
No, Your Honor.
And so, she doesn't have any criminal history, so, ma'am, do you think you can return to the home? Now, if you don't want to return to the home, you don't have to. I was just talking to him as far as what he wants. So do you wish to return to the home?
No, I have another place.
Okay,
Your Honor.
right. And that's totally fine. Marriage is not a prison. Marriage is not like the Department of Corrections. People, you're married to, and you love each other because you want to be with each other and you respect each other. But when the love and respect is gone, and that does happen, when it dissipates, it's gone, evaporated, then you need to move on with separate place to live and be respectful because you have children together. but you don't have to live together. Marriage is not a sentence. And so do you understand what I'm saying?
Yes, I do.
And so are you at the emotional point to where you no longer wish to be husband and wife or with him?
Exactly. I was planning to file for a divorce
Okay,
2 weeks ago.
right. You know, I've done thousands of divorces, mostly uncontested, and several hundred contested ones. And so, so really, it looks like you don't have much property. You just have some kids. And so it's a matter of where the kids will be and what child support there is. And so, so the point, speaking to the gentleman, you know, if she feels the marriage is over with, you can't keep her in a loveless marriage. If she doesn't love you anymore, you need to just move on. Do you understand?
Yes, Your Honor.
Now, the reason I take a couple of minutes to sort of put that all on the table is because because I'm going to be releasing her in a minute, and I want you all, beginning this afternoon and tomorrow, I want you all to realize there may be a new reality, and we have to respect each other. Because remember, she will always be the mother of your children, and he's always going to be the father of your children. And so you have to respect those roles, but you don't have to be married. Are we okay?
Yes, I agree.
Okay, so, all right. I think this will work. So I'll go ahead and do $100, $100 for your bail. So put up $100 as a bail money, and you can be released. And then you are to have no hostile contact, because you do have children, and you're going to go through a divorce, and so you're going to need to mediate and everything like that. And then, so no hostile contact, to live in separate residences. And before you know, you have to live in separate residences, and before you can live together, you'd have to come back to the court and ask for permission, because I don't want anybody intimidated or feel they have to. So I want you to be happy with the children, but you got to live separate, be respectful. You can't, which means have contact. You can't have contact. And I've given you a reasonable bond so you can get out of jail. There's no reason for you to be in jail. Okay, thank you very much, Ms. Moore.
Your Honor, state would ask for a one-time return with law enforcement, so Ms. Moore can return to get any belongings that she needs.
Okay, yeah,
as well as no weapons.
yes, if you have any items, or the children, I don't know how you're going to do the child thing. Usually you just divide the toys and everything, so the kids have toys here, toys there. But any stuff that you need to get, you call law enforcement, and they will go with you to the house, and then you can be there, or you don't have to be there. You can just leave it open and just tell them to come in and let her take what she wants. Because you have to be respectful. Whether you're married or not, you have to be respectful. No hostile. No hostile.
No hostile with a separate.
No hostile. If I misspoke, I apologize. Okay, Jessica Moore. Okay, now we have.
No hostile with a separate, one-time, no weapons.
Yes.
Because there's a separate residences.
Yeah, separate residences and a one-time return. Did I confuse you? I think I'm. Yeah, right. I guess one way or the other is the idea. They can either have no hostile, or if there's little hostility, we'll just go there with a deputy, and that's always better. I've had 2 women murdered. I think I said that earlier, since while I was a judge and in domestic relations court. And So, anyway, are you Mr. Norman?
Yes, sir.
Okay, Mr. Norman, you're arrested for battery, domestic violence, and we don't have anybody in the well, not the well, but the witness box or whatever that's called. And what was the relationship?
The relationship was, she's my girlfriend.
Right.
Your Honor, under the affidavit, the victim testified that they were recently separated. So ex-girlfriend, ex-boyfriend.
Mm-hmm. So has she gotten all of her stuff to your knowledge?
We actually live in the same house.
And she's moved into a separate place?
No.
She isn't, so she still has her stuff in your place?
Yes.
Or who
Our-
has
it's a
the
shared
lease?
place.
Who has the lease of the apartment?
I believe she does.
She does? Okay. And so I think obviously if she has the lease, it's just easier for you to move, to get your stuff and move. Okay. All right. Looking at your history, no particular history. So we'll go ahead and do we'll do a bond. The bail is $250, so we'll do $250 bail, and you are to have no contact with her. However, you can call law enforcement to go with you to get any stuff that remains at her place. And when I say that, I mean your clothing, tools, personal items of that nature. One-time event, you can go there. Do you have any firearms or ammunition?
No, sir.
Okay, and I don't see any real drugs in your past to speak of. And so, anything else?
Your Honor, so State would be asking that you order a separate residences since you ordered the one-time return, as well as order no weapons, just so he wouldn't be able to obtain any.
Right, separate residences. Okay. Okay, next we have,
Your Honor, can I have a moment to confirm with?
yes.
Thank you.
Okay, and are you Mr. Salerno?
Your Honor, would you consider, for Mr. Norman, can we still be heard on bond?
Oh, okay, we're going to go back on the record. We're talking again, we're on the record for Mr. Norman. Go ahead.
Mr. Norman informed me a lot of his money is at the residence, so he wouldn't have any money in his property here to bond out. Would you consider a lower monetary bond coupled with a pretrial release, so there's a non-monetary option for release?
Your Honor, generally this court, when they do, since the standard bond for a misdemeanor DV is 500, generally this court, when they set pretrial with bond, it's generally 250 with PTR. State believes the 250 is currently reasonable, given that they're arguably within the facts of this case is also potentially a false imprisonment. So State would ask that you stay the bond as you currently set it, as it's already lower than the standard bond schedule, and is reasonable given the facts alleged within this affidavit.
No, I think everything I've done is reasonable, and you're just going to have to figure out how to, everybody, a lot of people have the same problem, and just figure it out. Okay, next is Naomi. Naomi Salerno, Salero, and we don't have any witnesses. So this is a domestic battery, and looking at your history, out of state, child issues, disorderly, but But so was Yolanda, what is the relationship?
She's my sister, Your Honor.
Okay. And do you and your sister, anyone else live in the house?
Okay, so I'm here, Your Honor, on vacation, and I was present in the bathroom. My mom's gonna be 84 tomorrow. It's her birthday.
Okay.
And she can barely walk. Okay.
Yeah, I'm really trying
Yeah, the
to,
ones that besides there, because I was staying in my parents' house, is, my dad was there, but he was somewhere inside the
Okay.
house.
okay, so I just want to find out, so you're from out of state?
Yes,
Okay, what state?
Jersey City.
I couldn't hear.
Jersey City?
Oh, New Jersey?
Yes,
Okay. And so you came down here to visit with your parents?
yes,
Okay, and that's when the incident happened?
yes.
Okay. And who was the other, given all the different people, was it you and a cousin or somebody you got into a fight with?
No, it was my sister actually that attacked me.
Okay. Well, I don't see any real danger to the community. So,
Your Honor,
yes.
given that she is from out of county or out of state, she has no real community ties to this area. She did tell pretrial release that she does intend to return back to New Jersey after she's seen here at IA. Purpose of bond is to, one, secure her presence and secure the community, as well as the victim's safety, as well as balancing her own interests. And in addition to that, she does have a fairly lengthy, concerning out-of-state history of appears to be violent offenses, abuse, abandonment, cruelty and neglect, criminal mischief, disorderly conduct, stalking and harassment, or striking and harassment. Due to being out of state, I don't have any information on those cases. However, she does have.
Your Honor, I've spoken with our client. She's assured me that she'll speak with our office weekly, perhaps, to check up on any cases that she needs to appear for. She also, I'm sure, is well aware of the repercussions of not showing up for court because a warrant can be issued for her arrest all the way up in New Jersey. And a lot of times they put her on a long ride back to Florida. So I can assure the court that she will, in good faith, work with our office to appear for any cases in the future.
Okay. This, I'm not going to say it's a small incident, but it's not the biggest thing we're seeing this morning. But this small thing could become a big thing if you don't show up. And so I could put a larger bond to make sure the bond company will go get you or somehow arrange, make sure you come. But I'm going to go ahead and put your bail at $1,000, which is a reasonable amount for you to get out of jail. And then I want you to have no more contact with your family. I do authorize you to contact law enforcement to go to the house and get whatever luggage, clothing, whatever you have, and then reside somewhere else. Now, that somewhere else can be New Jersey, but make sure, like the attorney said, we have an excellent public defender office. They're very good attorneys. Follow their advice. Keep in contact with your address, your phone number, and so that this can be resolved. Otherwise, this little thing will blow up in your face. Do you understand me?
Yes, Your Honor, may I say something? During all this, my bags were already packed.
No.
And all my belongings are in my uncle's house.
Okay. All right. That's fine. Okay. At this point, no contact with all these people, your family members, and just get your stuff and go. All right. Thank you.
Your Honor, Steve would ask for no alcohol. This incident seems to have stemmed from her parents allegedly finding 20 bottles of wine.
Okay. All right. No alcohol, no illegal drugs. All right, thank you very much. And next we have, this is a warrant, I see. Next we have Edgar Aparicio. Okay, Edgar Aparicio. And so you have a warrant from Volusia County. They have a $2,500 bond on the warrant. And we'll notify Volusia County that you're in our jail. Thank you very much. Next, we have Aisha Golston. Aisha Golston. Aisha Golston. You, Ms. Golston? All right, we have a Seminole County warrant for you, so we'll notify Seminole County. Now, this says ROR. So,
Is that what you see, pretrial?
Yes, she's to be released on her own recognizance
Yeah.
after their first appearance.
okay, so after today, later this morning or this afternoon, you'll be released because it's a Seminole County, so driver's license, no driver's license. So you'll be released this afternoon, ROR, and then you need to, today or tomorrow, head up to Seminole and
Go to the court for the warrant?
and I do appoint the public defender in case it helps. All right, thank you very much. Next, we have warrants, felony warrants, VOPs. This should be Mr. Battle. Mr. Battle, correct?
Yes, sir.
All right, you were picked up for violation of your community control. It's a zero bond. You'll see the VOP court in the next 3 to 5 days. Thank you. Next, we have Timothy Dallas. Timothy Dallas.
Yes, sir.
Okay, you've been picked up for violation of probation. Bond is zero. You'll see VOP court in the next 3 to 5 days. All right, thank you.
All right, thank you, sir.
Next, we have Feliciano Rivera. Okay, are you Feliciano Rivera?
Yes, sir.
Okay, this is a violation of probation. Bond is zero. In other words, you don't get a bond until you go before the VOP court, and that'll be 3 to 5 days from now. Thank you. And next, we have Gene Joseph. Okay, Mr. Joseph, this is grand theft of third degree of a motor vehicle. This is a new charge. It's a $1,000 bond. And then you have
Your Honor,
violation of,
For conditions of that one, state would ask for no contact with the
okay,
victim
no contact
and no weapons.
and no weapons and no drugs or illegal drugs. Violation of probation twice, zero bond each, and you'll see the VOP court in 3 to 5 days. Next, we have Joshua Mates. Mr. Mates. Good morning, Mr. Mates. You have a violation of probation. Bond is zero. And you'll be in front of the VOP court in 3 to 5 days. Thank you.
Thank you, Your Honor.
Next, we have Ward.
Just a moment to confer, Your Honor.
Oh, yes.
And can our client be heard, Your Honor?
Yes, sir.
I would like to respectfully request that a bond be set under the, I have school and work that I need to get back to, and this is my third violation of probation, or my third hearing for the first appearance for this violation of probation, as I've been sitting, waiting in Volusia County for the past 30 days.
It doesn't sound normal, but I really don't know anything about it. And so, any issues as to why he isn't going to VOP court? And this is Mr. Ward, right?
Oh, this is
Mr. Can I have the paperwork back? Yeah.
Your Honor, his VOP, it's case number 2016 CF 2586. The underlying offenses were agbat, great bodily harm, battery by strangulation, and false imprisonment. The reasons for the violations is picking up a new law offense in Volusia County of leaving the scene of a crash with injury, December 4th, 2021. He's also a violent felony offender of special concern, so he does have the VFOSC hold. So state would object to bond at this time, given that he is not entitled to it, given that it is a VOP. He is a violent felony offender, and he violated by picking up a new law offense.
All right. I have to deny your request, and you'll go through the normal process. All right. Thank you very much. Quinta Ward. Quinta Ward. Medical, did you say?
Yes, sir.
Okay. This is violation of probation. This is zero bond. Can we just have her taken to the VOP court within 24 hours of?
Your Honor, we can waive her appearance for today, and then she would still appear in front of the probation judge.
Right, okay. Okay, next I have Williams, Quinteria Williams.
Yes, sir, that's me.
Okay, Ms. Williams, you have aggravated battery with a motor vehicle,
Yes.
and which is a $5,000 bond, and then violation of probation is zero, and you'll go to VOP court 3 to 5 days. Okay, thank you very much.
Can I have
Your
a
Honor,
moment to
for-
confer with her before we resolve?
Yes.
There are four conditions. It would ask for a no return to the scene, no contact with victims or witnesses, as there were independent witnesses on scene, no weapons, firearms, or ammunition.
Yes, granted.
Just a moment to confer, Your Honor.
Yes, yes. Then we have Bobby Green. Mr. Green. All right, you have failure to appear. There's a $2,000 bond in the
Is this a
KPS. There's a KPS $2,000. And
It was upside down. Your Honor, state did convey an offer to Mr. Green of an adjudication of guilt, credit time served, no return to the In-N-Out gas station located at 2012 South Orange Blossom Trail.
I believe there's comp concerns, Your Honor. I would just have you stay the bond amount, work with our office to resolve that in front of the division judge.
okay, all right. Okay, next we have James Bloodworth. Mr. Bloodworth, you have your sex offender violation, which is failure to register. The bond was set at $2,500 for, I guess it was a warrant.
Excuse me, sir. I have registered at the sheriff's department. They trying to railroad me, sir. When I got out, I went to the sheriff's department and I had registered as a sex offender, like they told me. I'm tired of coming to jail. Okay, I made the first mistake. I'm not always wrong. I went back to the sheriff department, told the man I was leaving. I was getting ready to go to my grandmama's house and gave him the address and everything. He said, oh, you got a warrant because you didn't go to DMV to register. They never told me I had to go to DMV. They said within 48 hours, report to the sheriff department when you get out and register.
All right.
And that's what I did.
It sounds like, you know, maybe there was a misunderstanding here.
Work it out.
Right,
I
but,
have a job, man, and I didn't do nothing wrong this time.
okay, but I can't help you. You do have public defender to represent you, and you have a $2,500 bond, and I can't change that because this isn't the right place to handle your dispute.
Oh, yes, sir. It's a third-degree charge. I'm not trying to hash you about it. Can I speak to my attorney? Can I at least speak to him? Being I'm paying for the attorney, can I speak to him? Because I'm getting railroaded as it is.
Well,
I'm being more.
this is initial appearance. I've given you your bond.
No one ever told me. Thank you. I'm sorry.
Yes, sir. Yeah, right. Right. This isn't the hearing that you'll have where you can argue your case as to what you did or didn't do. And so, but this is just for bonds.
Oh, thank you.
And so hopefully you can bond out, and it's a $2,500 bond.
No, I'm not going to bond out. I didn't do nothing wrong.
Okay.
I'm going to sit here as long as I can.
All right, we're
and
done.
work with my attorney.
Thank you very
because,
much.
I went
Nathan
to the sheriff's
Franklin.
department and I registered, but they
Nate-
said I didn't go to the DMV to register.
Okay, thank you very much.
It confused me. I'm sorry. Thank
Yes, sir. Yes, sir. Nathan Franklin.
We'll call.
you. Okay.
Nathan Franklin.
Oh,
I'm sorry, you Mr. Franklin?
yes, sir.
Okay. Mr. Franklin, you have possession of drug paraphernalia and disorderly conduct.
Yes, Your
And-
Honor. State did convey an offer to Mr. Franklin on the disorderly conduct case, as it is a city ordinance case. I've been authorized to offer him a withhold and credit time served. And in regards to 21 MM 9258, the paraphernalia, state would, no info that due to the plea to the disorderly.
Okay. Acceptable?
I did have a chance to speak with Mr. Franklin. I believe we went over the state's offer as well as the rights to be waived and the plea form for him to review. I believe he wishes to enter a plea of no contest. I'm speaking as a friend of the court, so there's no need to appoint us.
All right. Sir, we'll give you time served, which means you'll be released later today if you accept the offer. If not, we're happy to have set up for a hearing on another day. So do you wish to plead today or not?
Yeah, I'll go.
Okay, the gentleman, your attorney will give you a pen. I guess you have one.
He also needs to be sworn.
Needs to be sworn in to enter the plea, Your Honor.
Okay. All right.
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, help you God?
See,
Okay. And we've said on the record a moment ago, it'll be time served, the $50 attorney's fee and court cost, and reduce that to judgment. And so do you accept that, sir?
yeah.
Okay, so ordered. Okay, next.
Your Honor, to be clear, that was only a plea as to the municipal ordinance, correct?
Yes, right. And the possession of drug paraphernalia, I thought you, no problem.
State has an announcement as to 21 MM 9258. State announces a no information.
Okay, very good, thank you. Okay, next we have Mr. Hinkle. Mr. Hinkle, yes, sir. All right, Mr. Hinkle, this is trespassing. Now, there is a first appearance petty theft. He's out on bond, or let me go to it. Yeah, it's a surety bond. We'll go ahead and escheat that, and
Your Honor, state conveyed an offer to Mr. Hinkle of an adjudication, credit time served, no return. If he were to otherwise take that offer, state would ask that you take no action on his out on bond.
okay.
I did have a chance to speak with Mr. Hinkle about the state's offer as well as we went over the plea form. I believe he wishes to resolve today with a no contest plea.
All right, swear him in, please.
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, help you God?
Yes.
All right, do you accept what was just discussed, which is time served, adjudication, and this this other case, we have the bond, just leave it in place? Yeah.
If you otherwise please to this case, Your Honor, yes.
Okay, so we'll leave that bond in place and not revoke it. And on this case, we'll do $50 for the public defender, court costs, make it a judgment.
Your Honor, there's no need to appoint us. I spoke with him as a friend of the court.
Oh.
So he saves him $50.
Okay.
Your Honor, there was also a no return to 1406 West Sand Lake.
All right, no return and no contact with the salespeople, not the salespeople, but the clerks and people like that. So stay away from there, have nothing to do with the people. All right. Next, we have Coleman's Burger, Mr. Coleman's Burger. This is a petty theft, and I do see some paperwork down here that he's out on bond of another petty theft.
Yes, Your Honor, state did not convey an offer to the defendant, partially due to this being enhanceable. Second, that he's also out on bond for the exact same offense. So state would ask that you stay his bond on this case and revoke and double his out on bond.
You think you could double it? Don't revoke it, just double it. I'll pay double bond.
All right, as far as the bond that he's presently on, we'll revoke it and we'll make it $2,000. And then the petty theft, which is the current charge, will be $1,000. If you bond out on the current charge, or either charge, if you're to stay away from the premises, have nothing to do with the people, and no possession of firearms or ammunition. Anything else, State?
No, Your Honor.
All right, thank you very much.
To be clear, that was 2,000 on the out on bond 9008 case and 1,000 on the new case?
Yes.
Okay, thank you.
Okay, and next we have Demarius Saint-Juste.
Saint-Juste, yes.
Justy?
Yes, sir.
Okay. This is contributing to the delinquency of a minor, resisting an officer without violence. And you do have a fair amount of history here. I noticed here, but
Your Honor, state did not convey an offer due to potential other charges being filed, so state would just ask that you set reasonable bonds.
right, and this is, let's see, and what F level is this?
The resisting, I believe, is an M1.
Right, an M1, so
I believe the contributing to the delinquency is also, Your Honor.
both of them are M1s?
I believe so.
All right, so we'll go ahead and do $1,000 on each, and to have no contact with the witness to the victim, and have no contact with them, no firearms, no drugs or illegal drugs, I meant to say.
Your Honor, state would also ask for no return to the area as well as no contact with co-defendants.
Right, no contact with the victim, witnesses, co-defendants, or their relatives, and no return to the scene of the incident. All right, thank you. Next, we have Janice Vaughn, Ms. Vaughn. This is trespass on property after warning.
Your Honor, can I have some clarity as to where the trespass warning or the trespass order specifically applies? According to the arrest affidavit, it was under a bridge at the Colonial I-4 junction, so I don't know. I spoke with Ms. Vaughn, and she said she was on the sidewalk, but I didn't know if there was a particular piece of property that she was trespassed from, or can you be trespassed from under the overpass?
I believe there's an active trespass authorization in that area, so law enforcement has rights to. I'm not sure of a particular business. I'm not sure. Or there's just an active trespass authorization for the area.
Pardon me.
I know there's some shelters and then our offices sometimes nearby. I don't want her to be walking somewhere and being trespassed again. I was just clarifying for Ms. Vaughn.
But she was panhandling, this seems like, asking citizens for money. And then she got some money from a particular vehicle.
Yes.
And
I
so,
believe that would have been an ordinance, if anything, an ordinance violation. I don't know.
is this the right
Trespass is
charge
a
for the
sufficient charge.
facts?
Yes, Your Honor. I believe she was panhandling, which the officer could have filed also a disorderly for panhandling under a city ordinance. However, there was also an active trespass authorization, so the officer just arrested under that.
So trespass on property after warning. So I guess you're going to have to help me state, please. Where's the warning? You know, you usually get a trespass warning, and then if you come back, you can be arrested.
Yes, Your Honor. She had an active trespass under a different case number, 2021-344-658. That was her
But
previous warning.
Okay, but shouldn't shouldn't the warning that we're talking about? Right, I understand. The warning is a general warning, and then she apparently got arrested for violating it, and then she's arrested again for violating it.
She had an active trespass from the area from a prior incident. And then she went back to the same area where there was still an active trespass authorization. That is what
Okay,
her
active
warning was.
Okay, here, I sort of answered my own question just now. It says there is an active trespass authorization on this property, reference case, and then that's what you were talking about.
Yes. So she's been trespassed before, and there's an active trespass, so they didn't have to speak to anyone
All right.
about there being an authorization.
Okay, we'll do a $250 bond.
Your Honor, there was an offer to resolve the case.
Oh, there was?
Yes. I believe the state's offer was an adjudication of guilt, credit time served, and no return. I was just trying to get a more specific area so that Ms. Vaughn knows which areas not to return to. I don't.
Okay.
I assume for the court, I guess just the overpass at Colonial and I-4.
Yeah, I'm familiar with it.
I did speak with Ms. Vaughn about the state's offer as well as went over the plea form, and I believe she wishes to resolve today.
Okay.
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, you heard the discussion. Do you wish to plead today?
No contest.
Okay. All right, and we'll court costs and reduce it to a judgment.
Your Honor, there was a no return to the area.
And no return to the area. You're good. So no return to that area, or there would be another arrest. Okay, here we have Demarco Wilson. Mr. Wilson? Okay, Mr. Wilson, you're charged with trespass after warning, a similar situation, panhandling. And so, state public defender, what do you want to do?
Your Honor, state did convey an offer to Mr. Wilson of an adjudication, credit time served, and no return to the Food Lotto located at 2060 Americana Boulevard.
I did have a chance to speak with Mr. Wilson, Your Honor. Went over the state's offer as well as the rights to be waived and the plea form to review. I believe he wishes to resolve today.
Okay, swear him in, please.
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
Okay, do you accept the offer that was just proposed by the prosecutor? Would be time served, adjudication, no return.
No contest.
Okay, all right. We'll order that. Thank you very much.
Thank you, Judge.
Next is Elizabeth Hassell, or Hazel, Elizabeth, Hassle. Hassell.
As she's medical, Your Honor, if appointed, we'll waive the appearance today. So, failure to appear.
Okay, so that's medical, so we'll waive appearance. And there is a bond set at $500 already. Okay, then we have, I have a note that the next few are city and county ordinances.
May I have a moment to confer with our next client, Your Honor?
Yes. Thank you.
We're ready, Your Honor. Thank you.
Okay. I think, did you make an offer?
Is this Mr. Bennett?
Yes, this is Mr. Bennett, correct?
Yes, it is, Your Honor.
Okay.
State has made an offer on behalf of the city of a withhold credit time served.
Withhold, time served.
I had a chance to speak with Mr. Bennett about the state's offer as well as the plea form to review. I believe he wishes to resolve no contest today.
Okay, swear him in.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
Okay, you accept the offer?
Yes, I do, Your Honor.
All right, only addition will be court cost, and we'll reduce it to a judgment. Thank you very much, sir.
Thank you, Your Honor.
Next is Cyrus Brown. Okay, Mr. Brown, you're charged with disorderly conduct.
State has conveyed an offer to Mr. Brown on behalf of the city of a withhold credit time served.
Withhold credit for time served. Defense.
I did have a chance to speak with Mr. Brown about the state's offer, as well as went over the plea form to review. I did want the record to show that the object was a sleeping bag that was offered to Mr. Brown, as opposed to money or something that's usually in the city ordinance affidavit. But Mr. Brown still wishes to resolve no contest today.
Okay.
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
All right, do you accept time served? And
Yes, that's acceptable.
okay, all right, we'll go ahead and do time served, court costs, reduce it to a judgment. Okay, next we have Ferguson, Andrea Ferguson.
Hello.
All right, Ms. Ferguson, it says here you're out on bond for possession of cocaine and drug paraphernalia. It was a ROR, to be specific.
That one, it's the one after that.
And so we'll revoke the ROR and set a $250 on possession of cocaine. Let's do it as $250. Possession of paraphernalia, $100.
Your Honor.
Yes.
If I may be heard on that. I've spoken with Ms. Ferguson many times in the past. I feel that she may not be able to afford that bond if you would stay the ROR on the out on bond case, as she is willing to resolve the panhandling case before you as well. It's a time served offer. Again, I wouldn't like to see her stay here even on a $250 bond. I've spoken with her, as I said, and I believe she does have a good faith cooperation with our office as well as with the court.
Right, this is another one of those panhandling on Colonial.
Your Honor,
Yes, Your
just
Honor.
in response to counsel's last argument, she's failed to appear 4 times, her last one being in August of this year.
Yeah. All right, I'm going to leave the bonds as is, and the disorderly conduct. Does she still wish to plea or not?
Yes, Your Honor. I spoke with her about the state's offer of the withhold and time served on the panhandle. Went over the plea form as well, reviewed that. She wishes to resolve no contest today.
Plea or plea?
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
All right, do you accept time served and a withhold?
No contest.
Okay, all right, so ordered. Thank you very much.
So, Your Honor, you're in regards to the out on bond, you said you're gonna leave the bond, so you're still revoking it?
No, I'm revoking the ROR and putting her on the 2 bonds.
Okay.
Yeah.
Is that 250?
Right, what I
250 and 100.
what I said, it was 250 and then 100. Yeah, that's 350. That's what I thought. Okay.
So get out.
Well, you're out on warrant, but you have to bond out some other things.
Wait. So I'm not getting out now? Oh my God, how long?
Okay. Next is Denver Freeman. Mr. Freeman, you're charged with disorderly conduct. I don't see where you're out on anything, and so that's the only thing we're dealing with. State.
Your Honor, state did convey an offer to Mr. Freeman of a withhold credit time served on behalf of the city.
All right, sir. Okay, defense, please.
I did have a chance to speak with Mr. Freeman about the state's offer, as well as I went over the plea form. I believe he wishes to resolve today.
All right.
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
I do. All right, withhold time served, do you accept it?
Yes, sir.
And then there's court cost, which I'll reduce to a judgment. Do you accept that?
Yes, sir.
All right, so ordered. Okay, next is Felipe White.
He's here, Your Honor.
Okay, and you're Mr. Way?
Yes, sir.
Okay, Mr. Way, you're out on bond, $2,000 bond, possession of cocaine, ROW, and then indecent exposure. And so we'll revoke that bond, change it to $4,000. And then you are now arrested on disorderly conduct.
That's 3 different charges. So you said 4,000 on that case?
Let me, right, there's 3.
So
Possession of cocaine, yes, thank
resisting
you.
officer without violence and indecent exposure.
Yes, let me do it differently. Yeah, possession of cocaine, we'll go ahead and do as 2,000. And then the ROW, we'll do it 500. And the exposure of sex organs, I guess that's urinating in public or something of that sort.
In this particular case, Your Honor, it was according to the affidavit, this occurred 11/30 of 2021. It was during the course of self-stimulation. So masturbating, Your Honor.
Public urination.
Masturbating, Your Honor.
Oh, okay. All right, and then we'll do $1,000 on that. And so those are your new bonds. and disorderly conduct is today in front of us. So how do we wish to go ahead and resolve that?
May I have a moment to confer? As the bond has changed, Your Honor, we would just have you set an ROR on the panhandling charge. We'll probably be sitting here on the out on bond case.
Your Honor, states no objection to that.
I didn't understand.
On the current charge of the city ordinance violation,
Oh, the
we'll just,
present charge.
maybe request an ROR bond. He'll still be here on the out on bond, the higher amount on the out on bond case. So we would just request ROR on the current charge, the 21-436-822 case number. I guess is it
Right,
disorderly?
On the disorderly conduct, because that's what we're talking about, we'll do a $100 bond and on that case. All right, thank you very much. Next, we have Siobhan Cutler.
May I approach,
How we doing?
may I approach the bench, Your Honor?
Oh, yes, sir. State, come on up, please.
Oh, he's just dropping off.
Oh, okay. Thank you.
How we doing? Siobhan Cutler, sir.
Oh, I have a bunch of them over here, so, okay. Okay, are you Mr. Cutler?
Siobhan Cutler, sir.
Yes, sir. This is a failure to appear in court. There was a capias issued, $2,000, and that stays for as it is. Thank you very much. Next case, next defendant is Stephen Jerome, Jarem, Jerome. Okay. I have a note that says the next are felonies, are all felonies. This is Darley Ayers. Darley Ayers. She refused. We'll reset for tomorrow.
Your Honor, it's a no bond. Do you want to waive?
Your Honor, if appointed, we'll just waive the appearance. It's a no bond status.
Oh, okay, this is a, yes, failure of a defendant to appear, no bond, so there's, I will accept that and order it for this hearing. Next, we have, just a minute. Let's see, Tierra Fountain, Ms. Fountain? Okay, this is possession of meth, and
Your Honor, it's possession of MDMA with intent to sell or deliver.
okay, and that 15,000 is the standard bond for that?
Yes, Your Honor.
Okay. All right, if you make bond, then you are not to go back to the place of the incident. You're to have no contact with witnesses, victims, and you are not to possess or consume any illegal drugs, no firearms or ammunition, anything else, State?
No, Your Honor.
Okay, next we have Wilson Garcia Martinez. Is that a hyphenated, or is it run together?
No, it's separate, Garcia Martinez.
Yeah, that's what I figured.
Sir.
Our computer system doesn't probably do the hyphenation, so it just sort of runs together. Well, Mr. Garcia Martinez, You have possession of fentanyl, possession of heroin, and no valid license. This fentanyl bond is $1,000, heroin $1,000, and the no driver's license $500. Sir, if you make bond, you are not to possess or use or sell any of those, any illegal drugs, and you're not to return to the scene of this incident, and not to contact any witnesses, victims, or relatives. All right, thank you. Okay, Mr. Gibson, come on up. Your charge is one charge. They did drop possession of cocaine, so you only have one charge now, which is sale and delivery of cocaine. And then your bond is $2,500. And if you make bond, you're not to possess or sell any illegal drugs. You're not to return to the scene of this incident. Do not contact any witnesses, victims, or their relatives. No weapons or ammunition. Thank you. All right, thank you. Next is Shanice Green. Ms. Green. Ms. Green, this is a battery on a uniformed security officer, but also I see that you are out on bond, a surety bond for $2,500, and we'll revoke the $2,500 surety bond. We're revoking it, and we'll change that to be $5,000.
Your Honor, state would ask for a higher bond than just doubling it, given that that event happened in April of 2021. It's alleged that she punched the Lynx bus driver in the face. And according to her history, she's had at least one prior failure to appear that was also recent, a prior battery that was also recent, as well as a battery on a person 65 years or older, an agate with a deadly weapon DV. Her history seems to be incredibly violent, even though it's incredibly short. They're all violent offenses. She was out on bond for a battery on a public employee when she battered a uniformed security officer. So Your Honor, state would ask for, if you're revoking, they would ask for a revoke and $10,000 on the out on bond.
Okay, defense.
I think doubling it to 5,000 should be sufficient, Your Honor, because she'll also have a bond amount in the current charge as well.
Yeah, that's, State, I'll go ahead and grant your motion to change that 2,500 to 10, and then the battery on the new charge, instead of the 25, I'm going to change it to 5. And ma'am, if you have addiction or mental health issues, you really need to talk to the public defender's office. That office is very good. They have a lot of services, but reading the report and everything, there is some serious problem here. You seem like you're standing there politely. You've responded to me okay, and so you're basically a good person, but there's something wrong here where you have two similar violent incidents, and at least those are what's alleged. So I just encourage you to be honest with your public defender, because they've got services available if you need evaluation and medicine so that you don't feel angry and lose your temper. Anyway, well, good luck.
Your Honor, on her new case, they would ask for no contact, as well as a no return and no weapons.
Right. No weapons, no return to the scene of this incident, no contact in any of the victims, witnesses, or their family members. So thank you very much. Chantelle Henderson, Ms. Henderson, this is meth And this is just possession, so the bond is $1,000.
Your Honor, say would ask for no drugs or alcohol and no weapons.
Yes. No drugs, alcohol, no weapons, and just I did see a survey a couple years ago that 80% of everybody booked into the jail was positive for one drug or another, 80%. And so in some ways, I'm totally understanding and sympathetic to no drugs, no alcohol, and then the drug testing. But the only struggle I have with that is because so many of these people, that's their lifestyle. The first time they're drug tested, they normally are positive and they're back in jail, and you just set them up to, and I just, the problem is bigger than us three lawyers who are well-trained and experienced. The problem is just so much bigger. You shake your head.
I agree, Your Honor.
And I actually was a drug court judge for 3 years, so I ran drug court, and I really enjoyed it. It was very positive, and you really did see progress, but it's just, I don't know. Oh, well, it's just that frustration that all of us will deal with, and I just hate to set people up for failure. I want to set them up for success, but that's more in the sentencing phase. But anyway, all right, we've got to get back to business. Say again? Okay. And, all right, let's see, Hendry, Kania Hendry. Okay. Okay, and are you Mr. Moore? Yes, sir. Lorenzo Moore. All right, this is a failure to appear 3 different times. The bonds are 0 in each instance, and it's a capias. All right, thank you, sir.
What happened with Abraham Mendez Bamaca?
And next is I can't find the name on here. I know it's. What is this? Who is this? Is this, Moten or?
Hughes.
All right, if that's, check that, see if that's all Moten or did that get separated? Okay. Refuse, so can we?
What's the full name, Your Honor?
Yeah, we got paperwork a little.
What's the booking number?
Yeah, Moton. EG. All right. Want to just go ahead and reset for tomorrow?
They bonded, yeah.
Oh, he bonded. Okay, sorry. Okay, folks, let's see, Edward Ox. Okay, Mr. Ox, you're charged with burglary of a structure and $250 bail.
Your Honor, it's $2,500.
What did I say?
$250.
Oh, I meant to, I looked at and said the wrong thing. So thank you for questioning it. I have no ego in what I do. I just want to try to do it right. And so so thank you very much for helping me there. So burglary of a structure is $2,500. Petty theft is 150, and then the criminal mischief is 100. And sir, if you make bond, you are not to return to the scene of this incident, not to contact any witnesses, victims, or their family, and you're not to use drugs or alcohol, and you're not to possess any firearms or ammunition. Anything else, State?
No, Your Honor.
Okay, next we should have Nicholas Paradiso. Mr. Paradiso?
Yes, sir.
Okay. Sir, you're charged with count, let's see, it's a meth, and it's a $15,000 bond bail. And then there's another meth, it's 150, and then resisting an officer without violence, $100. If you make bond, you are to not return to the scene of this incident. Do not contact the victims or witnesses or any of their family members, and you are not to possess any alcohol or drugs. You're not to possess any weapons or ammunition.
Your Honor, just for the record, so the record's clear, count 1 is possession of MDMA with intent to sell or deliver, which is the reason for the high bond.
Yes, yes. I just didn't say it, yes, but thank you for clarifying.
Your Honor, if we can, Mr. Paradiso has been unemployed the last couple months. Would you consider a bond reduction on count 1?
Your Honor, state would object, given the amount of drugs within this affidavit, including the amount of indicia of sale, state would object. There were at least 13 baggies individually packaged. There was a cigarillo, a digital scale. The defendant tried to flee, had to be taken down by a taser, was constantly not complying with law enforcement. In addition, he has at least 2 prior failures to appear, as well as other violent and drug offenses. So state would object to a bond reduction at this time, given that the $15,000 is the bond schedule for MDMA with intent.
Even $10,000, Your Honor, would be sufficient to bring our client back in front of the court.
Especially for his failure to appear and some of the history that the state outlined. And I think this is a reasonable bail given his background. Thank you. And state, I do want to know about failures to appear and many of the things you pointed out, so thank you. That really helps me evaluate what I'm supposed to do. So thank you.
Yes, Your Honor.
Okay, next is Stephanie Pooley.
Medical?
Okay, medical. And this is a condition of violation of pretrial release, so it's a 0 bond anyway.
Are you waiving?
We'll waive the appearance, Your Honor. Yes.
Thank you. Thank you. James Primes, Mr. Primes, you're aggravated assault with a deadly weapon, and I think this is, and so I think this is the one I read where there was they got into a right. Do you want to die over a cup of coffee? It's a legitimate question. I guess. Actually, it was a very good question. But certainly we don't want that. So, and then battery on an firefighter, etc. Battery, touching, striking, actual constructive possession. So with your, $2,500 is too low for your history. So I'm going to go ahead and change that to be $5,000. And so $5,000 is appropriate for your history. Thank you very much.
Your Honor, state would ask for a no return to the 7-Eleven, no contact.
Right, no return to the incident, place of the incident, no contacting any of the victims or witnesses, no weapons or ammunition, and no drugs or alcohol. Next, we do have warrants. This is a warrant. Next is Gabriel Rodriguez. Mr. Rodriguez?
Yes, Your Honor.
All right, Mr. Rodriguez, there are 3 warrants out for your arrest. The bonds on those warrants are grand theft, third degree, $2,500, grand theft, third degree, $1,000, and then burglary of a conveyance, $150 is what those warrants were.
Your Honor, I believe it's different. I believe the bird conveyance is 1,000 and the grand theft is 150 on the 15813.
Grand theft is, I'm sorry, would you say that again?
I may be incorrect, Your Honor, as I don't have the warrant in front of me. I only have the affidavit. But on the 15813 case, I thought the burglary of a conveyance was 1,000 and
Okay,
the
burglary
grand
of,
theft was
okay, let me double check here. Okay, first off, I guess I really ought to have a more consistent procedure, and so I really ought to address outstanding bonds. So,
Your Honor, can I be heard to that?
Yes.
As he was out on bond case, I believe the facts in that case took place on November 24th, while the events in the warrant that he's before you on, those events took place on or about November 3rd.
Okay, right, he bonded out, date bonded, so date arrest. Okay, the date of arrest is November 23rd. So the question I think you're pointing out is, but if November 23rd, but is the current charges predate that?
The events in the current warrant predate the out on bond case. Yes, Your Honor.
State, can you double check that?
The date of incident for 15813 is 11/6. The date of incident for the 15812, date of incident for that case is 11/3, and then he bonded.
And he bonded on 11/23. That's, no, 11/23 is arrest. He bonded 11/30. So I've always used it as the date of arrest. Well, if they're arrested, they're in jail, so it's unlikely. But anyway, I want to thank the public defender. That is the law. That is and actually, it's both the law and the logic. Yeah, so you wouldn't revoke a bond for something that happened before.
Yes, Your Honor.
What is that, old ex post facto?
He bonded on his out on bond 12/1.
Yeah.
State's asking that you take no action on his out
All
on
right,
bond.
so the only thing I have is the one, the 30. So we'll take no action on the bond that was dated 11/30. So I want to thank the public defender for pointing that out, because we're here to follow the rules. That's what we're a country of laws, and not of men. No, nothing meant against men, but we're to follow the rules, and the rules should apply to everybody, rich and poor, white and black, and pink and yellow, and whatever. And so I thank the public defender for pointing that out.
Of course.
Okay, then the grand theft. Back to the point, I think, that the state was questioning and I need to verify. Okay, grand theft third degree. Grand theft third degree, $2,500. Okay, so that's one.
Yes, Your Honor, I believe it's on the 15813 case that I was asking about. The warrant has count 1, which is the Berg conveyance at 1,000,
Yeah,
and
so
the
that's
grand
that
theft at
count.
150.
Okay, and then here's the case number that 813, that ends in 813? Okay, they have count, okay. So, right, on this one, it would be the $1,000 and then 150. So the second count, as far as we're concerned, would be $1,000, and then the third count is 150.
There's only two counts, Your Honor, so count one is 1,000. count
Well, there's
two is
actually, well, okay, there's three.
It's two separate case numbers, Your Honor. There's not three counts, there's two cases.
Oh, okay. So, but on this paperwork here, there's three charges, but they're broken into two cases. Is that, I think that's what, so the case that is, it says burglary of a conveyance and grand theft third degree. That's case number 813, that ends in 813, and that's 1,000 and then 150. And then the other one, is 812, the case that ends in 812, and it is a grand theft third degree, and it's 2,500. Okay, are we all on the same page? You're welcome to look at this, what I've got up here.
I have the same thing, Your Honor. It was
Okay.
two counts, and that was the confusion.
Okay.
It's
All right,
yes for
then-
standard conditions.
Right, no return to the place of the incident, no contact to the victims or witnesses or their family, no weapons or ammunition, no drugs or alcohol. Anything else, anybody?
No, Your Honor.
One question for my other defendant.
A moment to confer, Your Honor.
Okay.
Those conditions are on both cases, correct?
Can we have an address for the no return order? Please.
1 second.
Do you have an address?
There is a not return to no return to the Walmart at 8101 South John Young Parkway. That is the address of the 15812 case. And there's a no return. There was a no return to the Marathon as well at 2902 West Sand Lake. So it's the Walmart on John Young and the Marathon on West Sand Lake.
Okay, everybody good? All right,
Thank you.
thank you.
Have a nice day.
Okay, next, Gabriella Rodriguez.
Yes, Your Honor.
Okay, Ms. Rodriguez, you're charged with cocaine, and the bond there is $1,000. And then possession of a Scheduled V controlled substance, $1,000. Possession of drug paraphernalia, $500. Possession of Schedule V controlled substance, $1,000.
Your Honor.
And then just one second, looking, emergency contact. So you have no history. And let me just glance at this, just to give me 1 second.
Yes, Your Honor.
Your Honor, she does have history.
She does have history.
Yes, Your Honor. Her last conviction was a grand theft. She has a prior DUI and a prior petty theft. And she has prior arrests for agbat, DV, felony battery, battery DV, and at least 2 prior VOPs showing an inability to comply with court order. So state would ask that you stay the
Okay.
bonds that you currently set.
All right, yeah, now I see that. Public defender, were you going to say something?
Yes, Your Honor. She otherwise does qualify for pretrial release, a non-monetary option on these charges. She has told their interviewer that she does suffer from drug abuse issues. So would you consider just straight pretrial release as opposed to a monetary bond on this? She'd also be monitored for any weekly drug tests that you may order.
State
Keep her
objects.
clean.
State objects to straight pretrial release, Your Honor, due to the amount of drugs located within the vehicle, and given that the law enforcement officer found her slumped at the wheel, engine running, paraphernalia within her lap at approximately 10 a.m. A concerned citizen called it in, and she has a prior DUI. So state is concerned regarding the victim's safety, or the public safety, as well as the defendant's safety, as well as she had approximately two different pill bottles with the labels ripped off of different drugs. If you are inclined to put her on pretrial release, state has no objection to her being on pretrial release. We would ask for bond with pretrial release. So state would ask that you half everything that you.
I'm going to leave the bonds as is, but I am going to add pretrial release, substance and abuse. No, you're not to do substance and abuse. You're to do drug testing. And, so we'll do drug testing weekly, pretrial release. And ma'am, if you're positive, the cocaine, I tell you, I know marijuana stays in your system approximately 30 days, but cocaine, I think, exits your system, if I remember right, pretty quickly. So I'll tell you what, now ma'am, listen to me. You have the public defender's office is an excellent law firm, and they are very good about drugs and mental health, because those are the two underlying problems of society and most of crime, domestic violence even. And so you have an excellent law firm to represent you, the public defenders. And so I want you to be honest with them. If you need addiction help or mental health help, then you need to be honest with your lawyers. And they have a lot of resources at their disposal, and they're very good people. But the state is representing the public and public safety, and we don't want public safety to be threatened anymore. With your history and with these, it's troubling, it really is. So when I was a drug court judge, I remember cocaine, and there were some others that go through the system quickly. So I'm going to do, let's go ahead and do the third week after she posts bond. I don't want to, so if she's in here a few more days or something, but when she's released, 3 weeks from that time on the same day, on that third week, I want her drug tested, because that should allow the cocaine or whatever might be in her system today to dissipate. And so 3 weeks from when she's released or goes on bond, or however way you want to say that, she's to start being tested weekly for illegal drugs. And so I'm going to give you a time, and if you have to commit yourself to a rehab center, or if you have to do whatever you have to do, I know addiction is difficult. You do it, because we don't want you here. We don't want you in prison. And so you seem like a very nice lady, but you're in trouble. But you're smart enough. You are smart enough, ma'am. I really see this. I see that you're smart enough to commit yourself to get well. And so I'm trying to build a structure in this very beginning that helps you help yourself. So public defender, wonderful resource. Whatever you can do to get yourself clean, and then I'm going to start checking you 3 weeks from now after you post bond. All right, so no weapons or alcohol, no return to the scene
Your
of the
Honor.
incident.
I just want to thank you so much. And I have been in contact with my mother and my children's father, and I am going to be checking in and getting help because this is not the road I want to go down.
Yeah.
I love my family, and I don't want to be a menace to society. I want to be a part of society, and I want to raise my children to be someone they're proud of. So I want to thank you.
All right, and, all right, thank you very much, and good luck. Okay, next is James Russell. James Russell,
Medical, Your Honor?
medical. So this is a warrant. There's a $2,500 bond in the warrant, so we'll leave it as is.
We'll waive the appearance as well, Your Honor.
Thank you. And next we have Jerome Sapp.
Your Honor, state would still ask for all the standard conditions, no return, no contact, no weapons.
Yes, yes, well, can we put those in there, please? The clerk, would you state them again for the clerk?
No return, no contact with victims or witnesses, and no weapons, firearms, or ammunition.
Okay, are you Mr. Sapp?
Yes, sir.
Okay, Mr. Sapp, you've been arrested, and are these all warrants?
No, Your Honor.
So I do see he is out on bond. Okay, failure to report or to register sex offender, ROR, so subject out on ROR, but there was somehow, I don't understand how they say $3,500 bond, but then this ROR. I don't understand that. Do you understand that?
Your Honor, I believe it originally came in as $3,500. He's ROR'd subject to a 33-day motion.
Oh, okay. All right. So, Mr. Sapp, you have a possession of meth, $1,000 bail, DUI with property damage, $1,000, possession of suspended driver's license, $500, moving traffic violation, driving while license suspended, revocation, $500, grand theft, third degree.
Your Honor, in regards to that case, state would be asking for a higher bond. Given the allegations within the affidavit, they are extremely concerning. The victim and owner of the vehicle was dropped off at Advent Health on 12/22. The victim was placed in the ICU for swollen intestines, a brain bleed, skull fracture, injuries to his tongue, and other things. I believe he is now stable. The victim recounts that he stopped at a hotel because he saw a friend. He remembers being struck by an unknown object in the back of his head and then getting loaded into the back of a vehicle and doesn't remember anything else. He states that at least 2 people beat him in the motel parking lot and does not remember any other characteristics and doesn't know what happened to his vehicle, which was the Dodge Charger. He was also missing his 2 phones, 2 Sprint Samsung Galaxy phones. There's also surveillance footage, which partially goes against the victim's account that he was not beaten within the parking lot. However, he does enter a room 5, and there is a black male who is then later seen dragging someone from room 5, who is presumed to be the victim, into his own vehicle and leaving the motel parking lot. The defendant is then found later in possession of the victim's vehicle as he gets the DUI. So it's particularly long and particularly concerning. So state would ask for a higher bond as to the grand theft motor vehicle, as state would argue that $2,500 is not enough given the victim's testimony, the cooperating surveillance footage, as well as the facts within just the case, Your Honor.
Okay. That grand theft third-degree motor vehicle. Is that an F3 or 2?
3, Your Honor.
And then moving violation, that's probably an F2 or?
The Dwellis
I-
is
I
an
meant-
M2, Your Honor.
I meant M2.
Yes.
Okay. And then possession of suspended driver's license, probably a M2 also.
I believe so, Your Honor.
Yeah, possession of meth is what?
It would be an F3. State's not asking for any changes on any of his others, as I believe they're reasonable, and they were at his own account. The possession and DUI and Dwellis. State's only asking for a bond increase on the Grand Theft Motor Vehicle.
Right. Okay. All right. Given the totality of that motor vehicle incident, we'll go and change that to be 10,000 for the Grand Theft Motor, third-degree motor vehicles, 10,000, and then the others would remain the same. And then if you do post bond, you are to not return to the scene of any, I know there's several scenes, but not to return to that motel, to the hospital unless you're a patient, and not to have contact with the victim, the witnesses, any of their relatives, no firearms or ammunition, and anything else, State?
No, Your Honor.
All right.
And Your Honor, regards to his out on bond, I'm sorry, did we address that?
I don't believe so. Your Honor, he is also out on bond for failure to re-register as a sex offender.
Oh, I guess I got distracted on that. So thank you. So yes, thank you, pretrial release, thank you very much. So we're going to go ahead and that was a failure to report or register sex offender. We'll go ahead and make that $5,000. Okay, next is Zorita Simpson. Zorita Simpson. All right, Ms. Simpson, you're charged with failure of defendant to appear. There's apparently capiases, and so there's 1 time, 2 times. So the first one is 1,000, and the second one is 2,000. And those are set by the judge for failure to appear. All right, next is Delena Thompson. Delena Thompson. Okay, Delena Thompson. Ms. Thompson, you're charged with possession of cocaine.
Yes, sir, unfortunately.
I didn't hear you.
Unfortunately. It's a no contest.
No. You're just here for bond today. Is this Miss Thompson? You Miss Thompson?
This is me.
You don't have to say no contest.
I don't know.
I don't think I have, this is a felony, so I don't have the authority to plea it out, which is what I think I hear you trying to say. And so anyway, possession of cocaine, and you do have a bunch of other things that would suggest some addiction issues. So I think the $1,000 is reasonable. So thank you very much. No possession, no illegal drugs or alcohol, and so we'll leave it at that. Okay, next we have Kevin Valaquez Ziegler or something close to that. I apologize. So Mr. Valaquez Ledger, this is a no bond situation. It is armed burglary of a dwelling with a firearm, armed burglary of a conveyance with a firearm, armed burglary of conveyance with a firearm, and then petty theft. And so everything is a zero bond. Thank you very much.
Your Honor,
So are you gonna make a PC challenge?
as to the charge, I believe it's armed burglary of a dwelling with the firearm. Is that the punishable by life?
Right, there's two of them.
Count 1 through 3.
1, 2, and 3 are.
Oh, I'm sorry.
Your Honor, can we have a second?
Armed burglary of a dwelling, and then the armed burglary of a conveyance. Okay.
Your Honor, can I be heard? Can defense be heard
Yes, sir.
on those first 3 charges, unless the state wants to make an announcement? No. Usually to hold a client no bond on a punishable by life offense, there does have to be proof evident presumption grade found by the court. As reading through the arrest affidavit, I believe the firearm was a BB gun, and the dwelling wasn't like a house or a home. It was like a business, so it may have been a burglary, or there's enough PC to argue a burglary of a structure. With that in mind, I would still have you set a bond on these charges, unless you find proof evident presumption grade, which is in line with the Florida Constitution, Florida statutes, and the rules of Florida rules of criminal procedure.
Okay, well, I think, you're right, you're questioning where proof evident presumption grade?
Well, I'm arguing probable cause first.
Oh.
Your Honor, I believe there's multiple issues that can be clarified. One, we need to get to PC before we even start worrying about proof evident presumption grade. Regarding PC, as currently charged, count 1 is armed burglary of a dwelling with a firearm. There is not a firearm. All the case law is very clear that a BB gun is not considered a firearm. However, it arguably could be considered a dangerous weapon. I do have case law as to dangerous weapon. It does say that that is a question for the jury, whether it is considered a dangerous weapon. That case goes into, it is a 4 DCA case, and I can provide it to the court if Your Honor would like. However, it goes into a rock, whether that is or not. Some courts have found that a rock is, some have found that a rock is not. Some have found a pocket knife is, some have found that it is not. So it is a question for the jury whether a BB gun could be considered a dangerous weapon. So if this court can find PC for armed burglary of a structure with a dangerous weapon, that is still a PBL offense. Same thing with count 2, armed burglary of a conveyance with a dangerous weapon, and count 3, armed burglary of a conveyance with a dangerous weapon. So the first, I believe, issue that this court needs to hurdle is a BB gun potentially a dangerous weapon, which is a question for the jury, as the burglary statute, 810-02, does not define dangerous weapon. That particular charge is burglary with a dangerous weapon or an explosive. It only defines explosive. It does not define dangerous weapon. So that's why it's a jury question, as it's not defined. So I believe that's the first hurdle that this court needs to determine.
Okay, that's fine. I do think that the question that was raised is a jury question, and there are lots of facts which can make it one way or another. And so that's really, I'm not here to judge facts, but whether there could be. And so that's a jury question. So the probable cause is a jury question. You raise interesting, I grew up with BB guns, and I used to kill birds with a BB gun, and rabbits too, occasionally, if they were close enough. But then on the proof evident presumption grade, for the record, since the objection was made, the initial appearance, and this is my position on this issue, initial appearance hearings are brief hearings for the purpose of informing the defendant of their initial charges and setting bail for most crimes. There has been no discovery. Relevant witnesses as to bail are not yet known or subpoenaed to testify, and information about the defendant and the crime is not fully known. At most, there is probable cause that a crime was committed and that the defendant appears to have committed the crime. In other words, both sides have not had time to prepare a full and adequate bail hearing. Initial appearance hearings are not full and not adequate hearings for setting bail in very serious violent felony cases. Initial appearance bail hearings do not satisfy the due process requirements of the United States and the state of Florida constitutions. Due process requires notice and adequate time to prepare. To hold an Arthur hearing at initial appearance bail hearings, as requested by the defense, would be a due process violation. Therefore, I set bail at this time at no bail, subject to the defendant's right to have a full and adequate Arthur hearing, and the state's right to proper notice and to be prepared. Okay, thank you very much.
Your Honor, may defense respond
Um,
to the court?
Say again?
May defense respond to the court's reasoning?
Oh, yes, yes, sir.
Through your reading, I believe you said that the proof evident presumption great finding needs to be done at a full Arthur hearing, a full evidentiary hearing, and that the due process is at stake here for our client. However, the Florida Constitution and Florida statutes and the rule for criminal procedure do suggest that to hold them no bond now at IA would either require a pretrial detention motion filed by the state, which I don't think is present here, or a proof evident presumption great finding, which it sounds like the court is woe to find because we haven't had that full evidentiary hearing. So I would beg the court to set a bond on these counts.
Your Honor.
The answer is no. No, I understand your argument, and I understand your argument. I just don't agree with it. So at this point,
Your Honor,
it's a no bail, and that it should stay that way until a proper hearing.
for the record, due to counsel's argument, the 4th DCA and the 3rd DCA are currently in conflict, and this issue is currently with the Florida Supreme Court. Nothing has come out of the 5th, so we have nothing on point, and the Supreme Court has not ruled on it yet. The 4th is under the impression in Thornton v. Jr. that proof evident presumption great does not need to be found at IA for the defendant to be held no bond, which I believe is the same belief that your owner holds. The 3rd DCA case is the case in direct conflict saying that it does. So I just want on record that under Thornton, this court does not need to find proof evident presumption great to hold this defendant no bond, in addition to the argument that you already, or the discussion that you've already put on the record.
May I respond to that, Your Honor? May I respond, Your Honor? There is case law in the 5th DCA, I believe it's Rosa v. State, as well as another case that differentiates the two processes, the finding of proof evident presumption great at IA or setting no bond, and then the full evidentiary Arthur hearing. They have delineated those two functions. So for today, as the court has mentioned, I am not prepared to do a full evidentiary Arthur hearing, but as far as holding them no bond under the Constitution, the statutes, and the rule for criminal procedure, there does have to be a finding of proof evident presumption great to hold them no bond. I know the court disagrees, because we've had,
right.
I'm not opening the argument again, but there is case law in the 5th DCA. That
Okay, but one of the purposes of a bond hearing is to protect society. And so when you've got armed burglary, firearms, all of the indicia that's in here, as a protection of society, it would be irresponsible for the appellate court, I think, or for it would be irresponsible for this court or any court to allow dangerous felons, as described in the four corners of the documents, to be out there. Who knows? And so it just is so contrary to the purpose of safety and due process, that I could never agree with that. And until an appellate court said we're going to do it different. But I do believe that it's a total violation of due process to not, because the state would have to start bringing in witnesses, and we'd have to set this over for another day, and we'd have to have a half-a-day hearing on each of these. And so, but just, oh, well, let the burglar, the guy with a firearm, just let him go. That's just preposterous. I respect the argument, but to me, it makes no sense at all. All right, folks, we've exhausted the subject, I think.
Your Honor, he is entitled to a bond on count 4, however, the petty theft.
Right, the count 4 petty theft will do $500.
And then state would just ask for a no return and no contact.
Right. Okay, now the next we have Maurice Watson. Maurice Watson.
Your Honor, if you don't mind, are you finding PC for what is currently listed?
Yes.
Or the things that state that is a structure, not a dwelling, and it's a dangerous weapon,
everything,
not a firearm?
for everything.
As listed by the officer, as listed by the state? Your Honor, the state made the argument that it wasn't a dwelling, it was a structure, and that it wasn't a firearm, it was a dangerous weapon, which will be a different statute. So are you finding PC for what the officer wrote, that the BB gun was a firearm, or PC for what the state?
What the officer wrote.
Okay.
Okay, and next, are you Maurice Watson? Mr. Watson?
Yes, sir.
Okay, you have failure to appear, tampering with physical evidence, possession of drug paraphernalia, failure of defendant to appear, no valid driver's license. Is this, okay, I do have a warrant for operating a motor vehicle. Let's see. Okay, a warrant section, we have operating a motor vehicle without valid driver's license, and there is a $750 bond, and then, so that has that, so that is controlled by that warrant. And then failure of defendant to appear, no valid driver's license. And is that a failure to appear in court, or? Okay. All right, $750, tampering with physical evidence, $1,000. We'll leave them. Go ahead.
Can the defense be heard as to PC on the tampering?
Yes, go ahead.
I believe in the arrest affidavit, he tried to throw it away, but it was recovered, the paraphernalia. So I would have you find probable cause for attempted tampering, but it drops it down a level.
State has no objection, Your Honor, so it'd say the same statute with the addition of 777.04 for the clerk.
All right, we'll amend it.
777.04, it's the same statute, it'll be the 918 statute and the 777 statute.
And we'll change this $1,000, we'll just make it $500. Since it was just a throwaway.
And officers did recover it, so it wasn't destroyed in any way.
So 500, I think, is adequate for that. Okay, sports fans, does anybody else have anything that I need to conclude?
We have one Spanish interpreter.
Oh, we do? Oh, Spanish. Very good.
Good afternoon. This is Dalia Romero, Spanish interpreter on the line. already sworn in today.
Okay, thank you very much. Okay, ask the defendant if he can hear you adequately and tell him to speak Spanish to you and you will speak Spanish and English to me.
Yes.
Okay, and sir, you are Abraham Mendez Mocha?
Yes.
And sir, you've been arrested for failure of defendant to appear in court. So let me get to that paperwork. Okay, I don't have the proceeding. It just says failure to appear. Let's see, on December 28th, deputy responded to assist transporting.
Your Honor, his failure to appear was for an underlying possession of meth, and he failed to appear at pre-trial conference on 12.
I'm not finding what he failed to appear at.
It's on the original failure to appear.
Oh, appear, case management, here it is. Defendant was, let's see, defendant failed to appear for case management conference on October 23rd. Revoked bond, okay, $2,000. So that judge made that as a $2,000 bond bail, and we don't touch those. But now you have aggravated battery with a deadly weapon.
Your Honor, in regards to these cases, state does.
No. I'm sorry, counsel. Could you repeat that for the interpreter?
I believe the defendant might be having trouble hearing you. Can you confirm that he can hear you again?
Yeah, can you speak again Spanish to him? They're having to adjust his headphone.
No se escucha. No.
I asked if he could hear the interpreter. He says he cannot.
Sí, escucho un poquito.
He says he can hear just a little, Your Honor. I'll try to speak up louder.
Okay, and
Your Honor.
State, you were going to say something.
Yes, in regards to the agbat with a deadly weapon, the 2 counts of that, state was going to be asking for a higher bond to both of those charges. To support that, state makes the argument that purpose of bond is to ensure he's back to court. He's already shown this court that he failed to appear in that other case. Also, he does have little to no community ties. I believe he was recently under the FBI alien admissibility under Section 212, as he is not a U.S. citizen. It is alleged within the affidavit, there are 2 victims. The first victim is Mr. Jose. There was an altercation in the men's restroom. The defendant pulled out a knife, started slashing him on his hand, causing a non-life-threatening injury. He then yelled at the other staff. A customer stepped in who was victim number 2 and attempted to calm him down. During the fight, that victim got his face slashed and stabbed him multiple times on his body. He is currently in critical condition at the hospital. The defendant then went on to admit to stabbing the victim multiple times and then stated that he was intoxicated. However, state's concerned regarding his prior failure to appear, his lack of community ties, and the fact that he is not a citizen, regarding securing his presence for future court dates, as well as protecting the community, as it seems like an incredibly violent offense that left at least one of the victims in critical condition. The state would just ask for higher bonds as to both of the aggravated battery with a deadly weapon, just concerned about protecting the community and securing his presence.
So is the aggravated battery with a deadly weapon, is that an F2 or F2, I would think, but maybe not?
They are both.
Or is it an F3?
They're both F2s, Your Honor.
They're both F2s, right. Defense, anything?
It's a reasonable bond amount, Your Honor. That's all we request.
All right, the failure of defendant to appear is already set, and then the both aggravated batteries, separate people, I'm gonna do $10,000 on each person, so it'll be $22,000, so it'll be $10,000 each aggravated battery and $2,000 as on the failure to appear because of the knife attack and as described in the police report. Okay, folks, if you do make bail, then you're to have no contact with the victim, the witnesses, or any of their family members, and you are to possess no firearms, no weapons of any sort, and you are to show up for your court hearings. And if you have any questions, you contact your attorney, which is the public defender's office. They are one of the best law firms in town, very experienced, good lawyers, and so you're in good hands, but you gotta work with them, and they will try to figure this out for you as your attorney. So if you do make bond or bail, that is, then you need to immediately contact your attorney. All right, folks.
They would also ask for a no return.
Say again.
They would also ask for the no return to the business.
Right, and no return to the business and no contact with the people and no weapons. Okay, are we done? Everybody?
Yes, Your Honor.
Okay, I want to thank everybody. It was a good day. We got a lot done, and I want to thank everybody for working together. I will be here tomorrow, and that's my last assignment